In the healthcare industry, marketers can be utilized to promote healthcare services and products effectively. However, healthcare providers must ensure that their marketing practices comply with federal and state laws and regulations. Compliance with Anti-Kickback Statute, AKS, is crucial, which prohibits offering or receiving remuneration in exchange for referrals of patients or for recommending any healthcare items or services. The following are some general guidelines to legally use marketers in the healthcare industry. Utilize safe harbor provisions. AKS has safe harbor provisions that provide protection to certain marketing arrangements if specific requirements are met. It is essential to structure marketing arrangements to comply with the safe harbors when possible. Establish fair market value compensation. When compensating marketers, ensure that their compensation is based on the fair market value of their services and not tied to the volume or value of patient referrals or business generated. Understand and comply with AKS. To legally use marketers, ensure that marketing arrangements do not violate the AKS by paying for referrals or recommending specific products or services based on financial incentives. Implement written agreements. Establish written agreements outlining the specific services provided, the compensation terms, and the duration of the agreement. Train and monitor marketers. Provide training to marketers on relevant healthcare laws and regulations and regularly monitor their activities to ensure compliance. Ensure transparency. Disclose any financial relationships between healthcare providers and marketers when required. Maintain a compliance program. Implement a comprehensive compliance program, including written policies and procedures, training, monitoring, and enforcement mechanisms. While not all marketing arrangements will fit within a safe harbor, complying with the safe harbor provisions can help reduce the risk of violating the AKS. Personal services and management contracts, employee compensation, and discounts are some safe harbor provisions applicable to marketing arrangements for healthcare services. The fair market value, FMV, compensation doctrine is another critical aspect of healthcare law that plays a crucial role in structuring agreements and relationships between healthcare providers and other entities, such as marketers. FMV compensation refers to the value of a service, product, or property in an arm's-length transaction between unrelated parties, each acting willingly and without undue influence or pressure. It represents the price that would be agreed upon by a knowledgeable buyer and seller under typical market conditions. Using FMV compensation helps to ensure that financial arrangements are not disguised kickbacks, bribes, or incentives to generate referrals or business for healthcare providers. In conclusion, healthcare providers must consult with legal counsel experienced in healthcare law to ensure that their marketing practices and arrangements comply with AKS, other applicable laws, and regulations. Compliance with the safe harbor provisions and fair market value compensation doctrine can help reduce the risk of potential violations and penalties.